versus Joseph Kllins. Case number 23 CF 5961, Trial Division 2. Verdict. We, the jury, find as follows as to count 1. The defendant is guilty of kidnapping as charged. During the commission of the offense, did the defendant personally carry, display, use, threaten to use, or attempt to use a firearm? Yes. During the commission of the offense, did the defendant actually possess a firearm? Yes. We, the jury, find as follows as to count 2. The defendant is guilty of sexual battery with a deadly weapon as charged. At the time the sexual battery with a deadly weapon was committed, was the defendant 18 years of age or older? Yes. Did the penis of the defendant penetrate the mouth? Yes. During the commission of the offense, did the defendant use or threaten to use a deadly weapon? Yes. During the commission of the offense, did the defendant actually possess a firearm? Yes. We, the jury, finds as follows as to count 3. The defendant is guilty of robbery with a firearm as charged. During the commission of the offense, did the defendant personally carry, display, use, threaten to use, or attempt to use a firearm? Yes. During the commission of the offense, did the defendant actually possess a firearm? Yes. We, the jury, finds as follows as to count 4. The defendant is guilty of attempted first-degree premeditated murder as charged. During the commission of the offense, did the defendant personally carry, display, use, threaten to use, or attempt to use a firearm? Yes. During the commission of the offense, did the defendant actually possess a firearm? Yes. During the commission of the offense, did the defendant personally discharge a firearm? Yes. During the commission of the offense and as a result of the discharge of the firearm, did the defendant cause great bodily harm to? Yes. We, the jury, finds as follows as to count 5. The defendant is guilty of robbery as charged. So say we all.
Case number 23 CF 5961, Trial Division 2. The clerk reads the verdict. Guilty of kidnapping, guilty of sexual battery with a deadly weapon, guilty of robbery with a firearm, guilty of attempted first-degree premeditated murder, guilty of robbery. Each count, each special finding answered the same way.
Yes. Yes.
Yes. One word repeated until it becomes a rhythm, a heartbeat, the sound of a door locking. Imagine a single spent shell casing sitting on a courtroom evidence table. The brass is still warm from being fired. That is the case. Small, unassuming. But it tells you everything about the weapon, the moment, and the man who pulled the trigger. Now imagine 5 of those casings. Each one a different woman, a different night, a different count, but every single one fired by the same hand. That is what the jury saw. That is what they confirmed.
Let's use numbers.
Jury number 4, is this your true and correct verdict?
That's not the right jury.
That's the number you had in meeting.
Yes.
Jury number 6, is this your true and correct verdict?
Yes.
Jury number 12, is this your true and correct verdict?
Yes.
Jury number 15, is this your true and correct verdict?
Yes.
Jury number 17, is this your true and correct verdict?
Yes.
And jury number 25, is this your true and correct verdict?
Yes.
Before we go deeper into what the documents actually show, make sure you're subscribed to the VerdictOrigin because we don't just cover the story, we follow the evidence. Joseph Kllins sat in that courtroom and told the jury he did nothing, that the women were lying, that the videos were wrong, that the DNA was a misunderstanding, that a 20-year-old student working her second job ran into his arms because she loved him so much she abandoned a pizza in a parking space. That is not an exaggeration. That is his sworn testimony.
Think about how each one of the victims who took the stand reacted. What was their demeanor? What did they tell you about what happened to them? But more importantly, think about why on earth each and every single one of them would have gotten on the stand to testify about the most horrific experience they have ever had, to sit in the same courtroom with the person who caused them that trauma, with cameras and a bunch of strangers, for what? What benefit have to having to take the stand and relive being forced to give oral sex to a stranger who had abducted her while she was working her second job? Think about the defendant's testimony as we go over each of these items of evidence. Her second job, she's a 20-year-old student and works 2 jobs. Left her first job after 10 o'clock at night to go make extra money to survive. And the defendant asks you to believe that she ran into his arms and disregarded a pizza into a parking space because she was so overwhelmed with the amount of love that she has for Big Head, his nickname. That she was just so overwhelmed, she jumped onto his person, forgot about her job, forgot everything. Everything he testified to had some kind of explanation because she was just so in love with him. That's why his DNA is all over her face and all of these things.
The nickname he used, Big Head. And the state attorney did not have to raise her voice. She simply asked the jury to use their common sense.
Ladies and gentlemen of the jury, the defendant, Joseph Kllins, is a who robbed and terrorized, victimized 4 women between April 18th and April 19th of 2023. The evidence in this case comes in the form of videos and maps and several witnesses, and that can prove to be overwhelming. So the purpose of talking to you in this closing argument is to address some of the things we've heard from all of those witnesses, to address the narrative that the defendant has just given you about his experience and what he alleges the evidence, having had the last several years to review every police report, every statement, having had the opportunity to sit before you and listen to each of those witnesses testify about what happened to them, what his version of events was. We'll have an opportunity to discuss that, why it doesn't match the evidence. But I want you to think back to...
Actions speak louder than words. 4 women, 4 separate accounts, 4 different vantage points. English was their second language. Yet every statement they gave 3 years ago matched every statement they gave in that courtroom. The defense tried to rattle them. Why didn't you throw yourself from the moving vehicle? Why didn't you escape? The attorney cut through it. None of those questions appear on your verdict form. Those are distractions.
Don't rehash the questions that were asked. Why didn't you throw yourself from the moving vehicle as he nodded off to sleep? That is not any of the options the judge just read to you on your verdict form as to whether the state has established that these acts occurred. Those are distractions. Same thing with, did you say in your deposition that he had little hair and beard and crazy eyes, or bald little hair? None of those elements of the crime.
The truth is simple. The facts never changed.
Traumatic event, your mind does not record memories like a video. Each and every single person that he victimized got in here and told you what they saw, what they witnessed from their vantage point when he did it. Your mind records and stores the memories of what you experienced in that moment. But remember that what the memories are that are stored are the facts that matter, because the facts that matter in this case did not change. They all were consistent with the evidence that was provided to you, with the exception of the defendant's statements. They all were consistent with what happened to them that night.
The stories never collapsed. Only one version of events shifted. Only one man changed his story when the video contradicted him.
Keep in mind the courage that it took for each person to take the stand and testify about what happened to them, physically, mentally, and emotionally, because they came into contact with one person, Joseph Kllins, and how that affected and changed their lives forever. He got on this stand and provided a statement that was so unbelievable. But let's point to the facts so that I can assure you that there is no question about the statements that each and every single one of those women told you when they came into this courtroom. Because at the end of the day, during a
Now the evidence. The aviation footage, the surveillance cameras, the timestamps. At 10:53 in the morning, the defendant is captured jumping a fence between two apartment complexes. He looks up. He knows the helicopter is there. He is holding his pants in the exact location where the victim said he had a gun and forced her to perform oral sex. The state did not need a confession. The state needed a map.
First amount of footage you have in this case comes from the video surveillance. After the vehicle from aviation leaves the scene of the shooting and goes to the entrance, it is 1:05:35 a.m. The video from the apartment complex next door, Haven, that we saw, from that parking lot where the defendant jumped over the fence, happens, and you'll see as the clock ticks down, the second aviation realizes that's your victim and points back to the original shooting scene. They've just missed the defendant who's hopped over the fence and gets away.
And the map showed one path from the shooting scene to the fence to the camera to the arrest. Joseph Kllins moved through that path like a man running from something, not like a man in love.
And when we are about to go over the video evidence, and you'll actually see the timeline and have an opportunity to see the timestamps and the time frames from which you see the defendant on camera and then the victims are having contact with law enforcement, there was no way anything other than the victim's statements of what occurred that night happened. There is no way that anything other than Joseph Kllins committing an abduction from that residence inn occurred. And Joseph Kllins forcing to drive around for 2 hours before taking her to that apartment complex occurred.
Here is the ticking clock. How long does a jury need to deliberate when every piece of physical evidence points in one direction and the defendant's own testimony collapses under its own weight? In this case, the answer was not long. The verdict was read. The defendant's first words were not remorse. They were in denial. Lying man. I not like that. Those are the last public words he spoke before being led to a holding cell. The same words he had said for 3 years. But now, they mean nothing.
What's going on, Mr. Kllins?
That lying, man. I ain't do no shit like that.
All right.
To that I don't want to tell Naya and them
Now,
what happened, man.
He goes in the holding cell. Make sure the closed circuit.
The moral refrain of this case, repeated 3 times across the timeline of April 18th and April 19th, 2023. The actions matched the evidence. The actions matched the evidence. The actions matched the evidence. Because that is what a jury is supposed to do. Not decide who is likable. Not decide who tells a better story. They decide what the physical record proves.
None of them. You had 4 individuals who, English is their second language, came in here and told you the same statements they told law enforcement 3 years ago. They provided through all of their testimony, through the physical evidence in this case, exactly what happened to them. And they have no reason to not be telling you the exact truth.
Record proves a firearm. This record proves forced abduction. This record proves sexual battery. This record proves attempted murder. The firearm enhancement was answered yes by every single juror. So now the case enters its next phase. Sentencing. Release reoffender designation had been discussed on the record.
All right, let's take a look. Under the prison releasee reoffender, we have to put in, you have found Joseph Kllins guilty of. You're probably a faster typer than I am, both of you youngsters over there. So if you could type those in and then just send me that one, because I've got everything else set up.
The judge asked the clerks to prepare the paperwork.
TV's working, Mr. Hackworth. I don't want you to go in, but I want you to go back in a few seconds and make sure the closed circuit TV's working that we've had set up. And he's going to watch this part from in there.
Yes, ma'am.
Okay.
The defendant watched from a closed circuit television because he had already been removed from the courtroom. That detail matters. He was not allowed to sit in the same room as the jury that just convicted him. He watched through a screen, remote, isolated, the same way his victims watched him for years in their memories. Here is what you should do next. Find the official docket for case number 23 CF 59961 in the public court records. Pull the verdict form. Read each count yourself. Then ask yourself one question in the comments. What does the gap between his testimony and the time-stamped video tell you about the nature of truth in a courtroom? Because that gap is where the entire case lies, not in the verdict. The verdict was inevitable. It lives in the moment a man looked up at a helicopter and knew he had been seen.
Ran away. He jumps over the fence. Although he also changed that and said that that's not him in the videos, that's fine, but this is the path of travel to the fence line where this video captures. The path of travel starts where the shooting occurs, where the defendant admits he was on the aviation video. And this video captures the defendant jumping over the fence at 1:05:30, just as the first victim is making contact with the officers at the front of the complex. Seconds later, captured on the next camera to the west. When he's captured on this camera, just as was pointed out when Detective Baranowski was actually, was actually on the stand, he looks up at the aviation.
If this breakdown gives you clarity on how juries actually weigh evidence, like this video, share it with someone who thinks a defense narrative beats a surveillance camera, and subscribe to the VerdictOrigin with notifications on. We rid the records so you don't have to.